right, Mr. Sneed, Nicole Quinones is a pickup, so she is not on your docket, just so you know, it's a violation of probation.
Thank you.
You're welcome. All right, this is in the matter of the people of the state of Michigan versus Nicole Michelle Quinones. We have 4 files, 21-20668 FH, 21-20669 FH, 22-20833 FH, and 24-22082 FH. Give me just a second. All right, so Ms. Quinones, we are here on 2 things on each file. Double check here. We have 2 violation request and warrants for probation violation on each file. So we have one dated January 6th of 2025, alleging that you were arrested on December 27 of 24 for assault and battery. 2, that you were involved in assaultive, abusive, threatening, or intimidating behavior against a Tuesday McLean. And the 3rd allegation on that file, on that violation, is that you failed to notify your probation officer within 24 hours of police contact on or about December 27 of 24. And then the other violation of probation on that file is dated January 7, that on, oh, it's looks like count 4, so it's an added count 4 to the violation, that you were arrested on December 27 of 2024 for disorderly conduct. So it looks like the violations are all stemming from some allegations or charges that you currently have pending, probably what you're in jail for now. You were arrested on those charges. So on file number 21-20668 FH, the maximum penalty for that offense, if you were to plead guilty, could be up to less than 200. That's a 93-day misdemeanor. And then on file number 21-20669 FH, assault and battery, that's a 93-day misdemeanor. Maximum penalty on file number 22-20832 FH, that's absconding bond attempted. So that is, I believe, a 2-year felony. And then on file number 22-20833 FH, another attempted absconding, which again, I'm pretty sure is a, let me get back there, 2-year felony. So, and okay, so ma'am, obviously you have some pending charges. So I wanted to advise you, you do have the right to have an attorney represent you on this. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes, ma'am.
Okay, thank you, Ms. Quinones. So what I'm going to do is enter a plea of not guilty on this, and then I will set this over to later this morning with a court-appointed attorney, all right?
Okay, thank you, Your Honor.
You're welcome. Thank you. I'll see you back later, okay?
Okay, thank you. They're just gonna appoint attorneys for me and see what that is. No paperwork.
All right, so. All right, so You need, I have an assistant attorney general and I see that M Clarissa. And I think it cuts off on my Zoom screen. So Clarissa is not your last name, that's your first name, correct?
Middle name. My last name is Williams.
Williams. Or last Williams?
Yes.
Yeah, okay. You should shorten the attorney general to AG and then your last name will show on my screen. So, Miss Williams, what is your P number?
84270.
Thank you so much. All right, so, yeah, Mr. Malaro. All right, Miss Adams, can you call the jail and let them know I'm ready for Mr. Malaro's clients? It would be, never mind, I'll do it. I shouldn't have asked you to do that. I'm sorry.
Nottaway County Jail, Deputy Miller.
Hi, Deputy Miller. It's Judge Anzalone again. So I am ready on Charles Gorton and Jonathan Maurer.
Sounds good. I'll get them in there for you.
All right. Thank you.
You're welcome.
All right. So Miss Underwood, I have Mr. Malaro. So let me, Miss Underwood, just so you know, we had a pickup this morning for Nicole Quinones on violation of probation. She did request court-appointed counsel. I set her over to the end of your docket. So whenever you're done with all your cases, we'll take that one. All right.
Yes, thank you. Is Mr. Newsome available for Ms. Williams?
Mr. Newsome is in person.
Great.
So
we're ready for that anytime, Your Honor.
Yes, Your Honor.
okay, Mr. Newsome, you want to come on up to the podium? We'll stand right there. All right, this is in the matter of the people of the state of Michigan versus Michael Robert Newsome, file number 24-22068FH. I have Rhonda Underwood appearing on behalf of Mr. Newsome, and I have Clarissa Williams appearing on behalf of the AG's office. This is a date and time set for a pretrial conference in this matter. It's actually the first pretrial in this matter. Ms. Underwood, how would you like to proceed today?
Well, we're very happy to report, Your Honor, that Mr. Williams is making his payments. It's going
Mr.
very
Newsome?
well. I've discussed this with the Attorney General's office, and we feel a 90-day adjournment is appropriate to give Mr. Williams time to lengthen his payment history, Your Honor.
You mean Mr. Newsome?
Mr. Newsome.
You said Williams, you mean Newsome,
Oh,
right?
I'm sorry.
Williams is on your list, but all right, so is that correct, Ms. Williams?
That is correct, Your Honor.
And Mr. Newsome, thank you so much for making these payments. So I'm going to adjourn this out 90 days, okay? So let's put this out to February, March, April 9th at 8:30 in the morning.
Okay, thank you.
All right, and I'm gonna get you a notice of hearing. So if you can just go have a seat right over there, we'll get you a notice of hearing for April 9th at 8:30 a.m. And Ms. Adams, could I get a notice for him? Thank you, Mr. Newsome.
So I will not have to prepare a stipulation, Your Honor?
No, he's here in person and I'd like to give him notice in person. So, all right, thank you, Ms. Williams. I think that's all you had with me.
Yes, thank you, Your Honor. Have a good day.
All right, thank you. Nice to meet you.
Thank
Yes,
you,
ma'am.
Ms. Williams.
You as well. Thank you.
All right, so. One. Who do I have in jail Zoom 3?
Mauer.
I'm sorry, could you say that again?
Mauer.
All right. And do I have Brooke Bates? Oh, she's in Zoom. So let's take Bates.
Middle.
This is Judge Anzalone. I cannot remember at this point. I am ready for Sierra Madrid as well, and I don't remember if I asked for her already.
Oh, that is all right. We'll get her out to you. Sierra Madrid.
Yes, sir. Thank you.
Yep,
Bye.
bye.
All right, Brooke Bates, can you unmute your device, please, and start your video? All right, Ms. Bates, thank you. And Mr. Where's attorney is Mr. Malaro. Mr. Malaro, while I take care of Ms. Bates, would you like a breakout room with Mr. Mauer?
Yes, just a couple seconds, Judge.
All right, so Mr. Mauer, I'm going to open up a breakout room with you and Mr. Malaro while I take another matter. So go ahead and join that breakout room. All right, this is in the matter of the people of the state of Michigan. Ms. Underwood, are you ready on Bates?
Is there a chance that I could talk to her?
Yep, I gotta call the case, but hold on one second. Miss Underwood.
Thank you so much.
All right, I think I've lost Miss Underwood for a minute. Okay. So I have another gentleman in the jail with a beard. What's your name, sir?
Charles Gordon.
Say it again.
Charles Gordon.
All right, good. Miss Underwood. So this is in the matter of the people of the state of Michigan. This is in the matter of the people of the state of Michigan versus Brooke Bates. We have 4 files, 24-21926FH, 24-21990FH, 24-22026FH, and 24-22065FH. I have Rhonda Underwood appearing on behalf of Ms. Bates. Ms. Bates is appearing via Zoom. I have Isaac Sneed on behalf of the people. I have a letter dated January 6th of 2025 from our pretrial services coordinator, Darren Coast, that states Ms. Bates has been doing swabs at the courthouse. She is always completely negative on all substances. She's done extremely well while out on bond. Sarah Teskey would like it to be a condition of bond that she participate fully with the drug court program. Ms. Bates is open to this idea as her screening cost would be covered. So Ms. Teskey, she's been approved for recovery court.
She has, Your Honor. I'm sorry.
She has, Your Honor. When I spoke to her last week, she was very indecisive about the program, so I don't know where she's at today with all of that. She was talking about if she took a misdemeanor, she didn't, if they were going to offer her a misdemeanor, she didn't want to be in the program, and she didn't want to take a felony just in order to be in the program. So I'm not sure where things are at this point.
Okay.
But
so Ms. Bates has asked for a breakout room with her attorney. So I am going to open up a breakout room and assign Ms. Bates and Ms. Underwood to that breakout room. Go ahead and join the breakout room. All right. Sierra Madrid, I'll be with you in just a moment, all right?
thank you.
Okay, so Mr. Malaro, I have Mr. Mauer back. So in the matter of the people of the state of Michigan versus Jonathan Remington Mauer, file number 24-22004FH, 24-22005FH, 24-22006FH, and 24-22007FH. I have Salvatore Malaro appearing on behalf of Mr. Mauer, and I have Isaac Sneed appearing on behalf of the people. This is, let me look here, date and time set for a pretrial conference. Mr. Malaro, how would you like to proceed today?
Your Honor, I believe we have reached an agreement as to all the felony files in this matter. And if the court would permit, I would take a shot at putting the plea offer and agreement onto the record.
There's multiple files, so I'm going to go by my docket. So I'm going to start with file number 24-22004FH. Could you give me the count or amended count and then what the plea is on that file?
Judge, that case is going to be nollied by the prosecutor's office as part of the plea
Okay.
agreement.
And then 24-22005 FH.
Yes, that's going to be a plea to carrying concealed weapon, 2 counts
that
of
a count?
felonious.
Can I have the
Uh,
count numbers?
Oh, I don't have that up.
Hold on.
Court, give me a minute, I'll pull it up.
I'll pull the felony information. I just need. Okay, so it's going to be on that file. What did you say he was gonna plead to?
You're gonna plead to count 1, count 2,
Okay,
count 3, and is it both? Let me look just a second, Judge. It's kind of a complex situation. And both counts, I think, counts 4 and 5, and the habitual offender notice will be dismissed.
so count 4 and 5, he's pleading to? Or
Yes.
being dismissed? So
He's
pleading
pleading to them.
Count 1, 2, 3, 4, and 5 as charged with no sub.
Correct. And Judge, it's going to be no contest plea.
Okay, no contest.
And the
Okay.
basis for those pleas are that due to the time that's elapsed and the time it took to restore Mr. Mauer to competency, it would be lack of memory.
Okay, then on file number 24-22006 FH, the felonious assault case, what will he be doing on that file?
Give me a minute, Judge. So, Mr. Let's see, you that's 06, right?
06, yes.
Yeah, Mr. Mauer's going to plead no contest to the 1 count of felonious assault. Habitual offender notice will be dismissed.
Okay. And then we are left with file number 24-22007 FH.
Yeah, just 1 second, Judge. Mr. Mauer again will be pleading to counts 1, 2, and 3, and the habitual offender notice will be dismissed at time of sentencing. And there will be no sentence agreement, Judge, between the state and the Mr. Mauer.
Okay, all right, and Mr. Sneed or Mr. Malaro, who will be placing the factual basis on the record. Somebody.
I didn't know he was pleading until today, so if I'm gonna do it, I'll need a break to review all those files.
That's fine.
I can take a crack at it, Judge.
Okay, all right, so I'm gonna pause you there. Ms. Underwood, with regard to Ms. Bates, are you gonna be setting another pretrial or taking a
Yeah.
plea today?
Yes,
Setting another pretrial?
yes.
Okay, so we're back on the record in the matter of the people of the state of Michigan versus Brooke Bates. Ms. Underwood, you're requesting another pretrial. How far out would you like that?
Very soon, Your Honor.
Well, my next available is January 29th at 8:30.
Thank you, Your Honor.
All right,
And I
so
will
Ms. Bates,
And I will be happy to do the dip and adjournment with Mr. Sneed's permission.
excellent. So I will set this, Ms. Bates, for another pretrial, January 29th at 8:30 in the morning. And we will see you back on that day. Thank you.
Great, thank you so much. Have a good day.
Hey,
You
hey,
too.
Brooke, I'm gonna see you on Monday, okay? 2:30?
At what time, 2:30?
2:30 on Monday.
Okay, I'll be there.
Okay.
Okay, so now we're gonna go back to Mr. Mauer. So Mr. Mauer, do you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you, Mr. Mauer. So, Mr. Mauer, you have heard the statement of your attorney and the prosecuting attorney, Is it your intention to plead no contest due to lack of memory on file number 24-22005FH to count 1, carrying a concealed weapon, which carries a maximum penalty of up to 5 years in prison or a $2,500 fine, along with mandatory forfeiture of a weapon? Count 2, assault with a dangerous weapon, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine. Count 3, assault with a dangerous weapon, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine. Count 4, police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine. And count 5, police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine. So is it your intention on that file to plead no contest to each of those charges?
Yes, ma'am.
Okay, and then we're gonna move on to file number 24-22006FH. Is it your intention to plead no contest on file, as I said, 24-22006FH to count 1, assault with a dangerous weapon, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine? So is it your intention to plead no contest to that count?
Yes, ma'am.
Okay, and then on file number 24-22007FH, is it your intention to plead no contest to count 1, carrying a concealed weapon, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine, along with mandatory forfeiture of a weapon? Count 2, weapons, dangerous weapon carrying with unlawful intent, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine, along with mandatory forfeiture of the weapon. And count 3, larceny in a building, which carries a maximum penalty of up to 4 years in prison and or a $5,000 fine. So is it your intention to plead no contest to those charges?
Yes, ma'am.
Do you understand the other file will be dismissed at the time of sentencing, and your habitual offender supplement for defense notice would also be dismissed at the time of sentencing? Do you understand that?
Yes, ma'am.
Okay. Are you satisfied with your attorney and the advice that he has given you?
Yes.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Your Honor.
Is that correct, Mr. Sneed?
Yes, Your Honor.
And Mr. Maurer, is that correct as far as you're aware?
Yes.
All right, so Mr. Maurer, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Maurer, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Maurer?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Okay, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Maurer, do you have any questions about the rights that I've given to you?
No. No, ma'am.
All right, so I'm going to go through each file, and your attorneys advise that you're pleading no contest. So your response would either be no contest or not guilty. Do you understand that, Mr. Maurer?
Yes, ma'am.
All right, so Mr. Maurer, on file number 24-22005, how do you plead to the charge that on March 3rd of 2023, in the city of Adrian in the county of Lenawee, that under count 1, you committed the offense weapons carrying concealed?
No contest, ma'am.
All right, and count 2, assault with a dangerous weapon.
No contest.
And count 3, assault with a dangerous weapon.
No contest, ma'am.
And count 4, police officer assaulting, resisting, and obstructing.
No contest, ma'am.
And count 5, police officer assaulting, resisting, and obstructing.
No contest.
All right, Mr. Maurer, we're going to move on to file number 24-22006FH. So, Mr. Maurer, how do you plead to the charge that on June 3rd of 2023, in the city of Adrian in the county of Lenawee, that you did commit the offense of under count 1, assault with a dangerous weapon?
No contest.
Okay, now we're going to move on to file number 24-22007FH. So, Mr. Maurer, how do you plead to the charge that on or about September 7 of 2023 in Madison Township in the county of Lenawee? I don't see one there. So hold on, we got to check that. How do you plead to the charge under count 1, weapons carrying concealed?
No contest, ma'am.
In count 2, weapons, dangerous weapon carrying with unlawful intent.
No contest.
And then count 3, larceny in a building.
No contest, ma'am.
All right, thank you. Ms. Teskey, we screened Mr. Benavides the other day and he was approved, correct? And screened? Well, no, he was screened.
No, he was supposed to be screened on Friday, Your Honor. I'm sorry. He was supposed to be interviewed on Friday and we are gonna bring him before the team on our next court date.
So he was screened and then we're going to review him this week?
We don't have court, Your Honor, until January 16th.
Okay, okay,
I'm currently writing a PSI on him as well.
okay. All right, so Mr. Benavides, he's been screened. And then next Thursday, we'll review his case in our recovery court program. So his sentencing date is still on. Yes, so we're good. All right, thank you. Good to see you. All right, I'm sorry, Mr. Maurer. I squirreled. I kind of focused on everything. All right. So, did he plead on all 3 counts on that file? Yep.
You were on count 3, yes.
All right, and so he did plead to count 3?
He did.
Okay. All right, so Mr. Maurer, has anyone made any threats or promises to you to induce you to plead no contest to these charges?
No, ma'am.
Do you understand if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Maurer?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Malaro?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
So, Mr. Maurer, I know your attorney already stated this, but that there was no sentencing agreement, but has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Okay, all right.
Your Honor, Your Honor, for the record, we did have a discussion about the sentencing guidelines, but I did indicate to Mr. Maurer that once the pre-sentence report comes out, it is up to the court to fashion what the sentence would be. Is that correct, Mr. Maurer?
Yes.
All right.
The only question that I have for all parties is docket number 22 or 24-2204. That docket's completely dismissed.
Yes.
Okay.
Okay. All right. And it's your own choice to plead no contest, Mr. Maurer?
Yes.
All right, so Mr. Maurer, we're going to put the factual basis on the record at this point. So Mr. Sneed, I would like to start with file number 24-22005. There are multiple charges on that, so if you can go
Judge, I
slow
can do
for
it. I
Oh,
think I can
Mr.
do it.
Malaro's gonna do it. All right, so as to count one, weapons carrying concealed, Mr. Malaro.
Yes, Your Honor, we believe that the state would prove beyond a reasonable doubt if this case were to go to trial on or about March 3rd, 2023 in the city of Adrian, County of Lenawee, State of Michigan, that Mr. Mauer did have about his person a fixed blade knife, on his person or about his person, in contrary to statutory law of MCL 750.239.
Okay,
Let me
count
just
two
go down the
and,
list, Judge.
yep, you can just keep going.
Okay. As to count two, Your Honor, we believe that on about March 3rd, 2023 in the city of Adrian, County of Lenawee, State of Michigan, that the state would be able to prove beyond a reasonable doubt that Mr. Mauer did, with that fixed blade knife, threaten Officer Bear, but without the intent to commit the crime of murder or inflict great bodily harm upon him, which would constitute the crime of felonious assault by pointing that fixed blade knife at Officer Bear, contrary to MCL 750.82. As to count three, Judge, we believe that on or about March 3rd, 2023 in the city of Adrian, County of Lenawee, State of Michigan, that the state would be able to prove beyond a reasonable doubt that Mr. Mauer did have that fixed blade knife and pointed it at Officer Mullen, but without the intent to commit murder or inflict great bodily harm less than murder, contrary to MCL 750.82. And he pointed that knife at Officer Mullen, and that both Officer Mullen and Officer Bear would testify that they were in fear of their safety by Mr. Mauer doing so as police officers. As to count four, Your Honor, we believe that on or about March 3rd, 2023 in the city of Adrian, County of Lenawee, State of Michigan, that Mr. Mauer the state would be able to prove beyond a reasonable doubt that Mr. Mauer did resist and obstruct Officer Mullen when he had reason to know that Officer Mullen was in uniform and acting in his performance of his duties by refusing to comply with the request of Officer Mullen when he was pointing the fixed blade knife at him, causing Officer Mullen to be in fear for his safety. As to count five, Your Honor, on about March 3rd, 2023 in the city of Adrian, County of Lenawee, State of Michigan, we believe the state would be able to prove beyond a reasonable doubt that on that date, Mr. Mauer did in fact resist and oppose it says Officer Mullen twice, but I believe it's probably Officer Bear. In the performance of his duties, Officer Bear was in full uniform and performing his duties, and that the resisting was that Mr. Mauer refused to comply with the requests and commands of Officer Bear with respect to the fixed blade knife, causing Officer Bear to be in fear of his safety. Is the court and the state satisfied?
All right, Mr. Sneed, any additions or corrections?
Just wanted to specify count 4 was for Officer Bear, count 5 was for Officer Mullen. Is that correct, Mr. Muller?
Well, they both say Mullen, but I imagine you're seeking an amendment.
Mine says Bear and Mullen. So I have count 2, John Bear, count 3, Brian Mullen, count 4, John Bear, count 5, Brian Mullen.
Well, the
And that's
information.
my October 22nd of 24 felony information.
I apologize, Judge. I was reading off the complaint in district court. Yes, officer count 4 is Bear, count 5 is Mullen.
Okay, thank you. I'm satisfied, Your Honor.
My bad.
All right, excellent. Excellent. So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on March 3rd of 2023 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of weapons carrying concealed by carrying a fixed blade concealed about his person. Count 2, pointing that weapon at Officer John Bear with the Adrian Police Department without the intent, and also count 4 to Officer Brian Mullen without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, but both parties were in fear of an assault. And under count 4 and count 5, with that same weapon, did assault, batter, wound, resist, obstruct, oppose, or endanger both John Bear in count 4 and Brian Mullen in count 5, who were Adrian police officers in their line of duty. And Mr. Maurer would have been aware that they were in the line of duty as they were wearing uniforms and trying to take them into custody. So the court does find that the defendant did commit the offense under count 1, weapons carrying concealed, count 2, assault with a dangerous weapon, count 3, assault with a dangerous weapon, count 4, police officer assaulting, resisting, obstructing, police officer assaulting, resisting, and obstructing in count 5, and accepts the no contest plea. That's 1. So let's move on to 24-22006 FH. Mr. Malaro, if you could place factual basis upon the record.
Yes, Judge, thank you. Judge, we believe that the state be able to prove beyond a reasonable doubt this matter were to go to trial that honor about June 3rd, 2023 in the city of Adrian, County of Lenawee, state of Michigan, that Mr. Maurer did make an assault upon one Brett Nelson with a dangerous weapon, to wit, a knife, without the intent to commit the crime of murder or inflict great bodily harm, contrary to MCL 750.82, to wit, after Mr. Nelson's dogs bit Mr. Maurer, Mr. Nelson confronted Mr. Maurer somewhere down the street from his residence. Mr. Maurer then pulled out a knife and threatened Mr. Nelson. Mr. Nelson was in fear of his safety by the actions of Mr. Maurer, therefore constituting the crime of assault with a dangerous weapon. Is the court and state satisfied?
Mr. Steen?
I am, thank you.
All right, so on file number 24-22006 FH, based upon the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on June 3rd of 2023 in the city of Adrian in the county of Lenawee, that the defendant did make an assault upon a Brett Nelson with a dangerous weapon, again, a knife, without the intent to commit murder or to inflict great bodily harm less than the crime of murder. So the court therefore will accept that no contest plea. So last file, file number 24-22007 FH, Mr. Malaro, if you'd like to place a factual basis upon the record.
Yes, Your Honor. We believe that the state be able to prove beyond a reasonable doubt if this matter were to go to trial, that on or about September 7th of 2023 in Madison Townships, County of Lenawee, state of Michigan, that Mr. Maurer did commit the offense of carrying a concealed weapon. To wit, he had 2 knives concealed on or about his person, contrary to MCL 750.239, and that he did not have proper permits in order to carry such dangerous weapon. We further believe that on that same date and time in the same location that Mr. Maurer was carrying those knives with unlawful intent, and with the intent to use same unlawfully against a person or of another, and the knives were more than 3 inches in length, contrary to MCL 750.226. And further, on that date and time, in the same place and location, that Mr. Maurer did commit the crime of larceny in a restaurant by stealing the tip jar at the Pizza Hut, by entering the building, taking possession of the bar, and I think he insinuated or brandished those knives in order to accomplish the crime of larceny in a building, contrary to 750.360. Is the state and court satisfied?
We have a Pizza Hut.
Yeah, it's like a little carry-out thing.
You're talking about Pizza Bucket?
Pizza Hut's down by Waddle.
No, it was the Pizza Hut. Wasn't it the Pizza Hut, Isaac?
By Starbucks.
That's correct.
Yeah.
In Madison
It's next to
Township.
the T-Mobile Starbucks place.
Oh, I didn't know that. Okay, good to know. All right, are you satisfied, Mr. Sneen?
I am, Judge. Thank you.
Okay, all right, so based upon the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on September 7 of 2023 in Madison Township in the county of Lenawee, that the defendant did carry 2 knives concealed upon his person without a permit to do so, that he did carry those knives with unlawful intent and entered Pizza Hut and stole a tip jar, committing the offense of larceny in a building, and therefore the court finds that the defendant did commit those offenses and of carrying concealed, carrying with unlawful intent and larceny in a building, and the court accepts the no contest plea. All right. Anything else, Mr. Sneed, on those?
Your Honor, I could just state on record that 2 misdemeanors in district court are also going to be dismissed.
All right, very good. All right, so pause away. All right, so has the court complied with the MCR 6.302 B, C, and D? Mr. Malaro,
I believe the court has, Your Honor.
Mr. Sneed?
Yes, thank you, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of any of them. I am going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, are you available to do a sentencing on February 21 at 8:15 in the morning?
Pretty sure I am, Judge.
Okay, so Mr. Maurer, someone from the probation department is going to come meet with you and they're going to prepare a pre-sentence report. You have pled no contest, so you don't have to make any statements about the events that occurred, but be truthful with them about your background. They'll prepare a pre-sentence report. I will provide that to Mr. Malaro. Mr. Malaro will meet with you in advance of sentencing to review that. And then we'll be back on February 21 at 8:15. Mr. Maurer, do you want to appear via Zoom or do you want to be in person?
Person.
In person? All right, so I'm going to mark the box in person for sentencing. All right, Mr. Maurer, thank you very much. We'll see you back then. Thank you. Okay, so I know Mr. Malaro and Ms. Underwood have to get down to Judge Olsaver, so let me check one more thing. All right, Mr. Gorton, I have Mr. Gorton, Mr. Malaro. So in the matter of the people of the state of Michigan versus Charles James Gorton, file number 24-21934FH. I have Salvatore Malaro appearing on behalf of Mr. Gorton, and I have Isaac Sneed appearing on behalf of the people. And I pulled this file. Now I don't know what I do with it. So it's here. There it is.
Your Honor, I apologize. Dan Gumto here. I'm appearing for the people, not Mr. Instead of Mr. Sneed.
Okay, so I have Mr. Gumto appearing on behalf of the people. Mr. Malaro, do you how do you wish to proceed today on behalf of Mr. Gordon?
Your Honor, I would like to have a breakout with Mr. Gordon.
All right, Mr. Gordon, I am going to pop you in a breakout room. All right, so hold on, jail Zoom 6 and Mr. Malaro. All right, Mr. Gumto, the prosecutors have trained me very well. So basically what they do is they keep their picture off, and when it's their case, they turn their video back on, and that's how I know who the prosecutor is. Okay, so let's see. Do I have Rhonda back? Rhonda had to go next door, so Miss Madrid, hold on just a minute. And same with Gordon. She's Rhonda.
Your Honor, I don't see Mr. Gordon on our docket.
He's on our docket. He is on page 3, second one down.
Okay, I found him. Thank you.
All right. So, all right, I have James Burton.
Judge, can I get a breakout with Mr. Gordon?
Oh, you want in there too, I guess. Okay. I thought I put you in there. I'm sorry. There you go.
Thank
All
you,
right.
Judge.
Mr. Burton in the courtroom, or is he?
He's here, Your Honor.
All right. So in the matter of the people of the state of Michigan versus James Ray Burton II, file number 24-21884FH, I have Michael Brooks appearing on behalf of Mr. Burton, and I have Isaac Sneed appearing on behalf of people. Mr. Burton, I need you to approach the podium with your attorney. Mr. Brooks, this is the time set for a final pretrial. Deadlines for all motions was December 11. Jury instructions of voir dire questions were due December 20th.
I believe you'll find the jury instructions in your file. I have no particular voir dire questions that I need to submit.
Okay, so are you ready to proceed to trial?
No. I just discovered, going through the information provided by the prosecutor's office, that in one particular, there are about 20 little video clips unconnected, each with the other. But in one of them, specifically on the date and time of the alleged crime, the police reports say that there were other people in that show, that there were other people in that building. And I submit they are race-just eyewitnesses who I know have not been listed on the prosecutor's information. And I submit that they should be. And I've been given some assistance in finding these people.
What are their names?
Give me a moment. Josh Matthews and Andrew Mellon. I just found them. I just spotted them. Like I say, there are over 20 clips, each more or less related to the other. And there they were.
All right, okay, hold on a second. Mr. Sneed, I believe Phoebe McClure is the trial prosecutor on this file.
She is, but I do have information from Phoebe that, if I could address the court, Your Honor. We received notice that one of the primary witnesses is undergoing open heart surgery and will be unavailable on the date of trial. And we wouldn't have an objection to a request to adjourn. And she did provide me with dates that could work for her if that's what Mr. Brooks is asking for as well.
In the interest of justice.
So are you asking for the opportunity to be able to locate and interview those people for trial?
Yes.
All right, so you're asking for an adjournment of the trial.
I agree with the prosecutor.
Okay, Miss Adams, can I have the 25 book, please?
I've been there and done that, as the court knows, and I know that's going to take a little while for it. So
I don't know that I have a trial date available in the anyway, but he's not in custody. Thank you. Can you mark those ones? Sure. Let me take a pause. Let's see. All right. All right, I can back it up to a jury trial on April 1.
That works.
I'll make it work.
Okay. All right. So that is a Tuesday, April 1 So I will do the scheduling order adjourning the trial to April 1 and April 2. And then we will get that out to everybody. All right? All right, very good. And that's 2 days. And I will allow Mr. Brooks to amend his witness list to add those 2 individuals, Mr. Sneed, without objection, or,
No objection.
okay. All right, you'll just need to provide that information through discovery rules to Ms. McClure, all right?
I also noticed, Your Honor, that the officer in charge, Officer Westgate, has been removed as a witness. The whole case is premised on her investigation, and I object to her removal. She's not a race gesti witness.
I don't, Mr. Sneed, do you know anything about that?
I don't, but if Mr. Brooks would like to subpoena her to testify, I believe he's free to do so.
Yep.
With this adjournment, I don't think that presents.
No. All right, I filled out a scheduling order. We'll get that out to everybody. Thank you.
Thank you, Your Honor.
And we'll take the trial off the book for January 14th. All right. Okay. All right. I think I don't know who was here first, you or Mr. Glazier? You were?
For who?
Oh,
Oh, we were first.
okay, all right. So, I just have, I just have her. So are you a we or is it just her?
I'm daily today.
Oh, you're daily today. All right, so signs? Okay, I have Mr. Signs in my waiting room. Okay, Mr. Signs has got to connect to his audio. All right, Mr. Signs, could you start your video, please? Mr. Signs, can you hear me?
Yes,
Okay.
hello?
Hello, can you hear me?
Yes, hold on a second. Let me stop. Fuck. I can't, hold on a second. Yes, I
There we
hear.
go. All right, because you don't appear here very often, I'll have you formally place your appearance on the record. So this is in the matter of the people of the state of Michigan versus David Royal Signs, file number 24-22047-H. Can you place your appearance on the record?
Yes, Carly Zoki on behalf of Mr. Signs, key number 79061.
And Mr. Sneed, are you the prosecutor on this matter? All right,
Yeah.
very good. This is date time set for a pretrial. How do you wish to proceed today?
Your Honor, we would request an adjourned, another pretrial. We would like to look into a cops agreement for Mr. Signs. He is in Harbor Light and has been there 90 days sober.
Excellent. Good job, Mr. Signs. So how far out?
20 to 30 days would be plenty.
All right, how about February 12th at 8:30 in the morning?
That should work for us.
All right, so Mr. Signs, I'm going to adjourn this to February 12th at 8:30 in the morning, same Zoom number. You keep up the good work, and Ms. Zoki,
thank
can
you.
you do the step in order to adjourn?
Yes.
Mr. Sneed, you can
Okay.
sign your name with permission.
Yes, please do. Thank you.
All right, Mr. Signs, thank you very much, and keep up the good work, and we'll see you back.
All right.
And I'll be
All right,
around
thank
today,
you, Ms.
Mr. Signs.
Angelo.
All right, thank you, and your attorney's gonna call you, okay?
Okay, thank you, Ms. Angelo. Bye.
Bye-bye.
Thank you, Your Honor.
Bye, thank you. All right, Mr. Malaro, I have Mr. Gorton back. So we're back on the record in the matter of the people of the state of Michigan versus Charles Gorton. Mr. Malaro, how would you like to proceed today?
I'd like my video to work. That'd be one thing. There we go. Your Honor, I'd ask to adjourn the matter. I'd like to schedule a bench conference with the court probably in about 2 weeks and maybe figure out a resolution to this matter.
All right, okay, so I'm gonna set the next pretrial for February 12th. Let me find them on my docket, February 12th at February 12th at 8:30 in the morning. Mr. Malaro, I would ask that you do the stip in order to adjourn. Mr. Gorton, if there is an agreement that is reached, your attorney will set up a time for you to come in sooner. So we would make, if there's an agreement that you want to enter into, your attorney will just call and we'll have you brought in sooner, okay?
Yes, ma'am.
All right, so Mr. Malaro, you can do the stip in order to adjourn, and Mr. Gorton, I'll see you back, if not sooner, by February 12th at 8:30. And Mr. Malaro, you can work with Ms. Adams to schedule a bench conference. Thank you.
Thank you, Judge.
Thank you, Your Honor.
All right, you're all set, Mr. Gorton. All right, so. Okay. All right, Mr. Collins. Mr. Glazier and Mr. Collins. This is in the matter of the people of the state of Michigan versus Darius Dwayne Collins Jr. File number 24-22082FH. I have John Glazier appearing on behalf of Mr. Collins, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Glazier, we had issued a show cause against your client because he has failed to do his twice a week drug testing as required. We have placed him on colors back on December 20th, and he has not done so. There was an admission to Mr. Coast on December 17th that he had used cocaine. I did not issue a bench warrant from that day because he always appears for court. So I held the bench warrant. He didn't appear for that day, neither did you. So I did not issue the bench warrant on that because, like I said, he's always showed up for court. So we have the pretrial as well as that today. So and I do have Mr. Coast here today. So Mr. Glazier, how would you like to proceed today?
Yeah, on the charge that's pending, he had been offered a plea to go through drug court. He does not want to take advantage of it. He wants to plead not guilty and have that set for trial, I guess.
So he wants to plead not guilty to the possession of methamphetamine and have it set for trial?
Yes, Your Honor.
Okay.
Your Honor.
Yes.
He's also on probation with me. I was notified this morning that he was pulled over and his vehicle was searched on December 24th, and they are submitting charges for drug paraphernalia. I mean, Mr. Collins is not doing what he's supposed to be doing on probation.
Is he testing for you?
No.
And Judge, I have yet to receive a drug screen result from him.
All right, can we test him today?
We can.
All right, so Mr. Collins, have a seat in the courtroom, and Mr. Costa come get you, and we're gonna do a test today.
Okay.
Mr. Glazier, if you wanna go take care of your cases next door and come back, that's
I
fine.
don't have, this is the only case I have.
So then you can hang out with me. All right, so Mr. Collins, you're gonna be tested today.
Mr. Gordon's still sitting in the room.
Hmm?
Mr. Gordon's still sitting in the jail room.
Oh. Yeah, because they have a limo.
Yeah, that's what he.
Oh, Mr. Gordon, you're all set, so if you wanna ask them, they'll let you out.
Okay.
All right, thank you. Okay, so, I didn't. So, Miss Attorney Marissa Boyles.
Yep, good morning.
Good morning. Your window says, your name says you're here for Juan Rodero.
Yeah, it might be
Is
under
that-
Rojas as well. It's Attorney Maxwell Dubin.
Say it again.
I'm here for Attorney Maxwell Dubin on the Juan Rodero. It might also be under Juan Rojas.
Well, I don't have either of them today. Are you sure you're here for Judge Anzalone?
Yeah, we've appeared on this one. I'm wondering if it was removed because it's set for a motion hearing on the 29th.
I don't know. Miss Adams, could you check that? Do you have a file number, ma'am?
Yes.
And we'll have someone check that.
Yep, it's 24-21942-FH.
Miss Adams, are you at your desk?
Yes, Judge, I'm checking. I see a pretrial January 29th at 8:30.
So we sent in a stip and order to have that day set for a motion hearing. So that's what I think we were appearing today for.
No, you just set your motion on the pretrial, I think. I don't have you for today and you're not in our system for today.
Okay, because we did talk to Mr. Sneed and we want to submit a stip and order for the motion hearing to be on the 29th.
But you're not on my docket for today, so I don't know. I can't call your case because I don't have a file and it's not set for today. Was it ever set for today, Miss Adams?
I don't see that in the computer, Judge. I don't know. You have the book, so I don't know.
We've never had it down for today, so I guess we'll see you back on the 29th, okay?
Okay, we did mail in a stip and order, so maybe if you get it in the meantime and we can set it for the motion hearing, but I guess otherwise we'll be back for
Know
pre-trial.
what your motion hearing, if you did a motion hearing, it wasn't for today.
No, I know. We did a stipulation and order with the prosecutor to have the motion hearing set for the 29th.
So what does that have to do with today?
Well, because we put it in the mail, so you should probably be getting that filing is what I'm saying.
But if it was set for the 29th, wouldn't you appear the 29th and not today? I guess I'm lost. I don't understand why you're here today. You were
Well,
never set.
we have it in our calendars, the pre-trial scheduled for today, so I don't know how or why, but that's what we have.
Okay, so it sounds like it's an error in your calendar, not a big deal. You're all set. Thank you.
Okay.
All right. Okay, let's get. Miss Underwood, I have Sierra Madrid. She's so in the matter of the people of the state of Michigan versus Sierra Madrid, file number 24-22093FH. I have Rhonda Underwood appearing on behalf of Miss Madrid, and I have Isaac Sneed appearing on behalf of the people. I have a letter dated January 2nd from Darren Coast, my pretrial services coordinator. She is presently in jail on a $1,000 bond on this case. She is also serving 6 months jail on a violation of probation where that case was terminated. Miss Madrid had an option being released early to go to inpatient, but probation officer McCarran states that this is no longer the case as she has a couple of new retail frauds pending in district court. Miss Madrid has not historically done well out of jail on bond conditions. She has failed the drug test required and doesn't show up for court dates. So Miss Underwood, how do you wish to proceed today on behalf of Miss Madrid?
Your Honor, we would waive.
Oh, wait, I'm sorry, I misspoke. This is actually an arraignment. So Miss Underwood, you waive the reading of the felony information?
Your Honor, we would waive the reading of the felony information, acknowledge its receipt, and to receive the witness list, and request for discovery. We would ask.
Mr. Solis in the jail, you need to be quiet. You're interfering with my record right now. Thank you. All right, Miss Underwood, proceed.
We would ask the court for a relatively quick pretrial date, Your Honor. It's our intention to have Ms. Madrid screened for recovery court in this matter, and we will be, since she's now upstairs, we will be filing that request today. So I would ask for a quick pretrial date for Ms. Madrid.
And you're asking the court to enter a plea of not guilty on her behalf?
I'm sorry, I couldn't hear you, Your Honor.
It's arraignment, so plea of not guilty, right? Is that what you said?
That's correct.
Okay.
I
All right, so the
apologize.
court, yep, I'm sorry. So the court will enter a plea of not guilty on behalf of Miss Madrid. I will set this for a pretrial on February 12th at 8:30 in the morning. That'll give you enough time to get the request for recovery court in, as well as giving us time to screen her. All right, Miss Madrid, your bond's continued. I'll see you back on February 12th at 8:30 in the morning, all right? Thank you. Okay, that takes care of Miss Madrid. Let me see here. Hold on, I see you, Mr. Smith. I'm going through my list of who's in order, and PDs do take precedence because they gotta keep going back and forth, so hold on. Shelton Hicks. Mr. Hicks, if you could unmute your device and start your video, please. All right, very good. This is in the matter of the people of the state of Michigan versus Shelton Martel June Hicks, file number 24-22050FH. I have Rhonda Underwood appearing on behalf of Shelton Hicks, and I have Alexander Bayonetto appearing on behalf of the people. I have received an amended felony information, and that is signed on January 7th by the prosecutor in this matter. Mr. Hicks, there you go. Now, Mr. Hicks, can you move somewhere where I have light on your face so I can see your face?
Yes,
Sometimes
ma'am.
when we sit in shadows, I can't see much. Okay. All right. Can you take your hat off too? I'm sorry.
Yes, ma'am.
All right. Okay, that's great. I can see it better now. All right. So, Ms. Underwood, I do have an amended information. How would you like to proceed today?
I believe Mr. Hicks is going to take the offer of the prosecutor in this matter, Your Honor.
What would the offer be?
Hang on. Let me get it up. I can't, Your Honor. I do not have a copy of the amended information yet. Mr. Hicks?
So I have an amended information as count 1, financial transaction device, count 2, motor vehicle unlawful driving away, and count 3, motor vehicle unlawful driving away. Mr. Bayonetto, can you tell me what the plea is?
I can, Your Honor. The
plea
plea agreement that was sent over to Ms. Underwood states that the defendant has agreed to plead guilty to attempted stealing or retaining a financial transaction device and attempted unlawful driving away of a motor vehicle. Those are the added counts 4 and 5. Your Honor, in exchange for a plea of guilty to those two added counts, there is a sentence agreement of no upfront jail. Mr. Hicks did spend I think a significant time in custody while awaiting his competency evaluation. Additionally, Your Honor, the people would dismiss the remaining counts and the habitual offender notice. I am not sure what the amount of restitution would be, if there is any. So that would be determined by the court at sentencing, and that restitution would be due to Dawn Bowman and Terrence Walton, if there is any restitution determined at sentencing.
All right. So the attempted stealing, retaining without consent of a financial transaction device, that is a 2-year?
Yes, Your Honor.
And then the attempted UDDA, that is a 2.5 year?
Yes, Your Honor.
Okay. Ms. Underwood, is that a correct recitation of the plea that's been offered in this?
That is a correct recitation, Your Honor.
All right. So, Mr. Hicks, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so Mr. Hicks, you've heard the statement of your attorney and the prosecuting attorney. So the plea offer that's been made in this case is to plead to a count 4 attempted financial transaction device stealing, retaining without consent. That carries a maximum penalty of up to 2 years in prison and a fine of up to $5,000 and then any restitution. Do you understand that?
Yes, ma'am.
And then there would be an added count 5 that the plea offer would be that you would plead to an attempted motor vehicle unlawful driving away. That carries a maximum penalty of up to 2.5 years in jail and or fines and costs. And there is a license suspension. Is that correct, Ms. Underwood and Mr. Banetto?
That is correct, Your Honor.
All right, so, all right, so your license would be suspended and then count 1, 2, and 3 would be dismissed, as well as your habitual offender 4th offense notice. So do you understand all those terms?
Yes, ma'am.
And you understand the agreement would be that there would be no upfront jail. So when you got sentenced, it would be fines, costs, and probation.
Yes, ma'am.
All right. Do you wish to take that plea offer?
Yes, ma'am.
All right. So, so you're going to plead guilty to count 4, attempted financial transaction device stealing, retaining without consent, and count 5, attempted motor vehicle unlawful driving away. Is that correct?
Yes, ma'am.
All right. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
All right. Do you, neither, other than the agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone else on the defendant's behalf has discussed any other possible sentence with the court? Is that correct, Ms. Underwood?
That's correct, Your Honor.
And Mr. Bayonetto?
That's correct, Your Honor.
And Mr. Hicks, is that correct as far as you're aware?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So, Mr. Hicks, do you have any questions about the rights that I've given to you?
No, ma'am.
All right, so Mr. Hicks, starting with count 4, how do you wish to plead to the charge that on or about April 25 of 2024 in Deerfield Township in the county of Lenawee, that you did commit the offense of attempted financial transaction device stealing, retaining without consent? Guilty or not guilty?
You said I was playing guilty, right?
Well, your attorney said you are. Do you want to plead guilty?
Yeah. Yeah, I'm gonna plead guilty.
Okay, thank you. And then on count 5, how do you wish to plead to the charge that on April 25 of 2024 in Deerfield Township in the county of Lenawee that you did commit the offense of attempted motor vehicle unlawful driving away?
Plead guilty.
Okay, Thank you. Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than the plea agreement?
No, ma'am.
All right, do you understand if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
So, Mr. Hicks, there's an agreement on the record that there'll be probation, restitution, but there won't be any upfront jail. Has your attorney made any other promises to you regarding your sentence?
No, ma'am.
Okay, and is it your own choice to plead guilty to these 2 counts?
Yes.
All right, so Mr. Hicks, on April 25 of 2024, did you have a debit card or a credit card or some kind of financial card that belonged to a Dawn Bowman?
Yes.
How did you get that card?
It was in the car.
Okay, so it was in the car and
it was a gift card.
Okay, so you got a gift card and it belonged to Miss Bowman?
Yes.
Okay, and you actually took her car and drove it away, is that correct?
Yes.
Did you know her, or was it just a car with the keys in it?
Just a car with keys in it.
Okay, and so you took that car and you didn't know her at all?
No, ma'am. I wasn't
right.
in the right state of mind, ma'am. I was going through crisis.
Okay, but she didn't give you permission to take that car, did she?
No, ma'am.
Okay, and and that was a Ford Fusion, does that sound right?
Yes, ma'am.
Okay, and then in that car was a gift card, so you took that gift card too. What was the gift card for?
Like one of them gift cards you scratch off and use them at like a gas station or like a store.
And did you use that card?
No, ma'am. It was
All right,
never.
but
It was never scratched off. The car was never scratched off, and the officers received the car back.
okay, all right, Mr. Bayonetto.
I think the only thing Ms. Bowman never gave you any permission to take that card either, right, Mr. Hicks?
No, no, sir.
Okay, I'm satisfied otherwise, Your Honor.
Right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Bayonetto?
It has, Your Honor, yes.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. The court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone else acting in the interest of either of them, obviously, other than the Killebrew agreement to no upfront jail. So I am going to refer this matter to the probation department for a pre-sentence investigation. So Mr. Hicks, in a minute, I'm going to put you in a breakout room with Sarah Teskey. Okay, so you'll get an invitation to join the breakout room, and I'm going to put you in there with Ms. Teskey from our probation department. Okay, she's going to give you some instructions. She's going to set up a date that you need to come here to meet with them because they're going to have to interview you. Okay.
Okay.
Are you able to get here?
Yes, ma'am.
Okay, so you have to make that appointment because if you don't, you could get in trouble. So when you meet with her, you need to be truthful about what happened in your background. She'll prepare, or someone will prepare a report. They'll provide that to Miss Underwood, and Miss Underwood will review that with you before sentencing. And I'm going to set sentencing in this matter for February 21 at 8:15 in the morning. Are you available that day, Miss Underwood?
That's fine, Your Honor. Thank you.
All right, now, Mr. Hicks, you can either come in person or appear via Zoom for sentencing. What would you prefer?
Zoom if I can, because my sister be have to work.
Okay, so we'll set it via sentencing. That's fine. All right, so Mr. Hicks, I'm gonna open up a breakout room right now, and I'm going to put you and Miss Teskey into that breakout room. I gotta find you.
Judge, did you say there's a Killebrew agreement on this?
To no upfront jail.
Okay.
Okay. All right, so Mr. Shelton, you should be getting an invitation. Go ahead and click join and go talk with Miss Teskey. When you're done, you can go on your way. All right? Okay. Miss Underwood, I have hold on. I got
Do we just have Ms. Quinones left, Your Honor?
that's a pickup. I'm not going to do that yet. I'm still moving through my docket. I'm sorry. I'm not ready for that one yet. All right, Mr. Smith, you are here, and then Mr. Glazier or Mr. Malaro. I have Miss Turner here. So let me take care of Mr. Smith. Where is he?
Last page.
No. Oh, there we go. Mr. Woltheis is in my waiting room, so hold on.
Then I'll be back, Your Honor.
All right. All right, Mr. Woltheis, can you hear me?
Yes, I can.
Excellent, very good, thank you. So this is in the matter of the people of the state of Michigan versus Stephen Richard Woltheis, file number 24-21734FH, 24-21938FH, and 24-21939FH. I have Russell Smith appearing on behalf of Mr. Woltheis. I believe these are pre-trials. So Isaac Sneed appearing on behalf of the people. So Mr. Smith, how would you like to proceed today?
Judge, I just substituted in these matters. I will need time to get up to speed. Perhaps we could set an additional pretrial for February 12th if it meets with the court schedule.
Yep, February 12th would be fine. So I'm going to set a pretrial for February 12th at 8:30 in the morning. And Mr. Smith, can you do the stipend order to adjourn? And Mr. Sneed, can you sign your name with permission?
Yes, he can, Your Honor. And good morning, Mr. Smith.
Good morning, Mr. Sneed.
All right. So we are all set, Mr. Woltheis. February 12th at 8:30 in the morning, and your attorney will do the notice of hearing. All right.
Yes.
All right. Thank you.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
Okay, let me take care of her and then I've got you, but Mr. Malaro, I have Navi Turner. Mr. Malaro, do I have Mr. Malaro? Yeah, I have Mr. Malaro. Mr. Malaro, Ms. Turner, you want to come up to the podium? All right, so this is in the matter of the people of the state of Michigan versus Navi Justice Turner, file number 24-21849FH. I have Salvatore Malaro appearing on behalf of Ms. Turner, and I have Isaac Sneed appearing on behalf of the people. So Mr. Hicks, you're all set. Mr. Hicks, I'm gonna remove you, okay?
Okay.
All right, you have a good day. Bye. Okay, so Mr. Malaro, I have, let's see here. All right, so we've adjourned this several times. Mr. Malaro, where do we stand at this point?
Your Honor, at this time, I'd like to set the matter for jury trial.
He's garbled up, Judge.
We can't hear you, Mr. Malaro. I'm so sorry.
About now, can you hear me now?
Yep, I can hear you now.
At this time, Your Honor, we'd like to set the matter for jury trial.
So the plea offer I show is attempted aggravated assault, which is a 6-month misdemeanor, right? Is the ag assault the 1 year? Yeah, it's still 1 year.
Yes.
And then under HIDA with no upfront jail. Is that right?
That's correct, Your Honor.
Okay. All right. So, looks like based on the charges, this will be a 1-day trial. And I can.
Judge, it's probably going to go 2 days, given the witnesses.
Okay.
Would you agree with that, Mr. Sneed?
Yeah, no objection, Your Honor. Sam.
Mr. Malaro, is Mr. Barry still proceeding to trial?
As far as I know, yes.
Okay, so I have Wednesday, April 23rd.
Let me look at my schedule, Judge. That's probably okay. Yeah, that's fine, Judge.
All right, so we'll set trial for April 23rd at 10:30 a.m. I'm going, and I'll get you a copy of this today, Mr. Turner, okay? And then I'm gonna set a final pretrial for April 9 of 25 at 8:30 in the morning. And let's see, voir dire questions and jury instructions will be due by March 28th. And I will make April. If there's any motions, I will make April 9 the deadline on those. That's right. All right. So I filled out a scheduling order. Let me fill in her information. Mr. Malaro, we will get a copy out to you and the prosecutor. And I will give a copy to your client today. So Ms. Turner, it's very important, and I'm sure you are, stay in contact with your attorney to prepare for a trial, okay? And make sure he always has an updated phone number or address for you. All right, Ms. Adams, could I get a copy of this from Ms. Turner, please? All right, so have a seat back with, and we'll get this for you. Okay. So that's that one. All right, Jill, I need Alphonse. Let's see. Oh, Jill, here people going. Hold on, Mr. Solis.
County Jail, Deputy Miller.
Hi, Deputy Miller, it's Judge Anzalone again. So I do have a bunch of windows open. So I am ready for Daniel Sloan. I am ready for Alphonse Edwards, Castro Oliveras.
Okay.
So Sloan, Edwards, and Oliveras. I have Mr. Solis, so I should be good then.
All right, sounds good.
All right, thank you.
You're welcome. All right, bye-bye.
Bye-bye. All right, so Mr. Solis, let me get your paperwork. All right. This is in the matter of the people of the state of Michigan versus Juan Mauricio Solis, file number 25-22099AX. So Mr. Solis, we are here on an extradition hearing.
Yes.
And this is a proceeding to determine whether you wish to waive your right of extradition. This is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state for your surrender and to return to that state to face the crime with which you are charged. So looks like, I'll find it here. Looks like you are charged in the Court of Common Pleas, Wood County, Ohio, with a warrant nationwide pickup for trafficking in cocaine and possession of drugs. And that is a felony in the state of Ohio, okay? We cannot, in this court or in this state, determine the truth or falsity of the charges made against you in the state of Ohio. So we don't determine innocence or guilt. You do not have to waive your right to extradition. You can require that the governor of the state of Ohio make a demand upon the governor of Michigan for a warrant for extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, the court will appoint you one at county expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. So do you understand the charges I've just told, or the rights that I've just told you? Do you want an attorney appointed to represent you?
No, we just been wanting to get this over this for a while now.
Okay, so do you want to waive your right to extradition, to a writ of habeas corpus, and to an attorney and go voluntarily to the state of Ohio to face the charges made against you in that state?
Go voluntarily, yes.
Okay, so did they give you the paperwork already?
I have not received anything. I was originally.
Knock on the door and tell them you need to sign your waivers, so they need to get you your waivers. I can call them too.
Please. I do apologize for the disruption earlier. He was talking to me about my diabetic medication. Man.
Hold on, Mr. Solis. So this is Judge Ann Sloan. Mr. Solis needs the 4 copies of his waiver of extradition to sign.
Okay, I'll let him know.
Well, he's in my waiting room. Okay, thank you.
I'm gonna let the sergeant know to send him up.
Okay, thank you.
You're welcome, ma'am.
So Mr. Solis, the audio is kind of funky in that room, so I need you to scoot up a little bit. Thank you. All right, so I've talked to them. They're gonna bring the paperwork for you, okay? So we'll pause for a minute, okay?
Yeah.
All right, so. Sam Malaro, where you at? There you are. I got Charity Smith. Then I got somebody else on an iPhone. Sir, are you for a case or just watching?
Yeah, Noah Lamley.
Okay. Yep, you have Mr. Murphy. Yep, he's next door, so he'll be back in just a minute, all right? All right.
Judge,
so
if that's Mr. Lamley, Mr. Murphy directed me to handle his matter for him.
All right, Mr. Lamley, come on up here to the podium, to the microphone. Ms. Teskey, I saw you speak with Mr. Collins. Did you give him a test?
He was unable to produce, Your Honor, so he is waiting in the hallway.
Can we do a swab as well? I don't know if Mr. Coast did. Okay. Okay, so this is in the matter of the people of the state of Michigan versus Noah Lamley, file number 24-22063FH. Mr. Malaro is kindly stepping in for Mr. Murphy to handle this today. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial. Ms. Adams, he's in person, so I will need a notice of hearing for him. So Mr. Malaro, how did Mr. Murphy wish to proceed today on behalf of Mr. Lamley?
Your Honor, Mr. Murphy has requested that I ask to adjourn the matter for him to discuss the issue of restitution. So we'd ask for an adjournment.
All right, so Mr. Lamley, I'm going to set this over for a pretrial to February 19 at 8:30 in the morning. And if you want to just have a seat back where you were, we'll get you a notice, okay? All right, thank you. Thank you,
That was
Mr.
the
Miller.
219, Judge?
Yes, sir.
Thank you.
All right, so I have two gentlemen just came into jail Zoom rooms. So I have a gentleman in Zoom room 3. What is your name?
Castro Oliveris.
All right, and I have a gentleman in Zoom room 5 with glasses on. What's your name?
Alphonse Edwards.
All right, thank you. Mr. Solis, did they bring your paperwork yet?
Not yet.
Okay, thank you. All right, so hold on one moment. So Mr. Degemer, give me just a moment. All right, no one said Dan. Do I have Daniel Sloan too?
Yeah.
All right, Miss, all right, come on. So Mr. Dagger Mr. Muntz was here before you, so I'm gonna take hers real quick, all right? So, all right, this is in the matter of the people of the state of Michigan versus Daniel Robert Sloan, file number 24-22044FH. I have Katerina Dumont appearing on behalf of Mr. Sloan, and my prosecutor is Isaac Sneed appearing on behalf of the people. I do have a letter dated November 14 of 24 from my pretrial services coordinator, Darren Coast, stating that a pretrial assessment was done on Mr. Sloan at the jail. Mr. Sloan has been in jail since October 28th on a $21,000 bond. He is also serving, at that time, he was serving 120 days in jail for a probation violation. He scored a 9 on the assessment, the maximum score allowed. He has a lengthy criminal history, a lack of work history, and substance abuse issues. So he scored high in terms of whether or not he should be released on bond. So, Mr. Mont, how do you wish to proceed on behalf of Mr. Sloan today?
Your Honor, I am just covering for Mr. Daly. We did not have a plea offer in this file until this morning. So what I would ask for is a quick adjournment, a short adjournment for another pretrial. I know Mr. Daly has it on a schedule to go visit with Mr. Sloan in the jail and advise him of the offer and then go from there.
All right, so Mr. Sloan, I'm going to set this for a pretrial on January 22nd at 8:30 in the morning. Mr. Mont, you do the stipend order to adjourn. Mr. Mont, once Mr. Daly meets with Mr. Sloan, if Mr. Sloan decides to avail himself of the plea bargain, I really appreciate if we can bring him in on a day, not a Wednesday. I can bring him in right away.
Okay.
All right? Yeah. So Mr. Sloan, I will see you back January 22nd, if not sooner. All right?
All right, thank you.
All right, thank you, and thank you, Mr. Mont. All right, so let's go back. Mr. Dagger Margosian is here next. So Michael Dagger Margosian, start with Alphonse Edwards. So this is in the matter of the people of the state of Michigan versus Alphonse Eugene Edwards, file number 24-21995FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Edwards. This is the date and time set for a pre-trial conference. So, Mr. Dagger Margosian, how would you like to proceed?
Your Honor, I'm going to need a moment with Mr. Edwards, if that's okay.
Of course. So, Mr. Edwards, I am going to open up a breakout room. Let me get there. Close these rooms. Mr. Edwards is in jail Zoom 6. So, hold on. Want to take your hat off, Mr. Collins? All right, I'm gonna open that room. Go ahead and join that to talk to your attorney. Any paperwork yet, Mr. Solis?
Yes, yes, Your Honor.
Awesome. All right, so Mr. Solis, if you could, in the middle of each document, it gives you an area to date and sign. It's January 8th of 25. If you can date it.
He left me no pen. He left me no pen. He was in a hurry and left.
Okay, got it. Mr. Coast.
Yes, Judge.
Mr. Collins, did you do a swab?
I did not do a swab. We have to do a urine screen, Judge, so I could get immediate results. We've tried twice. He hasn't been able to go. I was going to try here in a couple minutes.
I'd also like a swab that we can send in too if we need to. Thank you.
Absolutely. Thank you.
All right. I'm sorry, from the jail. I'm sorry. So Mr. Solis now has the paperwork, but he doesn't have a pen to sign it with.
Okay, I was going to give him that. We had a medical, so I had to step away real quick.
Not a problem. Not a
I'll
problem.
give that to him right now.
All right. Thank you.
You're welcome.
Bye.
Bye-bye.
Okay, let's start again.
Darren might be done that one.
All right, Michael Daggerman goes in, has Mr. Oliveras, and then, didn't we do? All right. Charity Smith, all right, Mr. Malaro, there you are, we're back with Charity Smith.
Hello.
Hi, Charity Smith, hold on. Mr. Malaro, in the matter of the people of the state of Michigan versus Charity Christina Smith, file number 24-22056. I have Salvatore Malaro appearing on behalf of Ms. Smith, and I have Isaac Sneed appearing on behalf of the people. There's like so much going on up here with the gentlemen. Okay.
Your Honor, that's my case.
Oh, Mr. Bayonetto appearing on behalf of the people. So, Mr. Malaro, how would you like to proceed with Charity Smith today?
Yeah, I think I just
Mr.
saw.
Collins, we're in court, so you need to be quiet. Thank you. Mr. Malaro?
Your Honor, I think I just saw a pre-trial plea offer in the file that I need to discuss with Ms. Smith. So if we could adjourn this one time and then I'm sure we'll get it resolved by then.
All right, so I'm gonna set this over to February 5 at 8:15 in the morning. And Mr. Malaro, can you do the stip in order to adjourn?
Yes, I will do that, Your Honor.
All right, so Mr. Malaro, of course, I always love when you guys call me and get pleas in on any other day than a Wednesday. So if you're able to reach a resolution, just call my office and I'll fit you in somewhere for a plea and you'll do the stip in order to adjourn. So Ms. Smith, we'll see you back, if not sooner, on February 5 at 8:30 in the morning, all right?
Yes, ma'am.
All right,
Thank you, Judge.
thank you. Okay, Mr. Solis, any pen yet? Good. So the audio again in your room, I don't know why it's so bad. Maybe try it sitting farther back. I don't know. So what I'm gonna ask you to do at this point is sign the documents that have been handed to you. They're waivers of extradition. And then you're gonna date January 8th of 25 and sign. It's kind of right in the middle and you need to sign each copy.
Okay.
While he's doing that, I am sending a request to unmute to someone on an iPhone 4. All right, what is your name?
Juan Rojas.
All right, so Mr. Rojas, there was some confusion. Do you speak English?
Yeah, I speak English. Always I request to speak Spanish. That
So
way
there
I can
was-
understand better.
Hold on, there was some confusion today, so you actually didn't have court today, all right?
Okay.
So call your attorney, okay?
Okay.
All right, thank you, Mr. Rojas.
All right.
All right. And I guess I can get Ms. Keone's back. This poor Jill's gonna be sick of hearing from me. Oh, she's in booking, never mind.
Your Honor,
Yeah,
while you're in between cases, Mr. Collins admits to methamphetamine and cocaine use.
okay, hold on one second. Hey, this is Judge Anzalone again. Sorry to bother you, but I am ready again for Nicole Quinones.
Again, all right, I'm good.
All right, thank you, bye-bye. All right, he admitted that today.
Yeah.
Did you hear that?
Yeah, I heard it.
Okay. Okay, So, I still want a test, so.
Okay, then
did
Mr.
they do
Coast
this-
is gonna attempt the tests again, the urine,
Well, I
and
wanted
then
a
if not,
swab too. I wanted a
Okay.
swab too to send off. Okay, okay, okay. All right, so Mr. Glazier, let me get you a copy of the show cause. The affidavit.
Can I get a mic, please?
Yeah, so might you guys come up to the podium or by a microphone? All right, Mr. Solis, did you sign all of those?
Yes, ma'am.
Want to raise your right hand? Do you swear that the signing of those papers is your free act and deed for the purpose of waiving extradition?
Yes.
All right, so Mr. Solis, I wish you the best of luck. They'll get that paperwork over here, I'll sign it, and then you should be on your way in the next, usually Toledo picks up pretty quick, or Wood County picks up pretty quick, all right?
Thank you, ma'am.
All right, good luck to you. All right, Mr. Collins has exited courtroom with Mr. Coast, so, okay, so we're waiting for Miss Quinones, we're waiting, oh, I got booking, great, so. Miss Adams, did I send all the Quinones files back with you by mistake?
I'll check, Judge.
Okay, sorry. All right, so let's see, I'm waiting for Miss Quinones. Michael's still in the breakout room. All right, so Miss Quinones, we are back on the record, and I have an attorney here for you to speak to, so I'm gonna open up a breakout room, and
Okay.
you and your attorney can speak, okay?
Okay, thank you.
Jail. Hold on, I gotta find it. Hold on, Miss Adams, hold on. Miss Adams, you want these? And do you want Solis? Okay, I think that's it. All right. Okay, so I'm gonna go through my docket real quick. Mr. Collins is out in the hallway. Doing that one. No. Mr. Edwards is in a breakout room. Mr. Oliveras is waiting to speak to his attorney. Charity Smith and already took care of that one. All right. Well, I think that's the last three we're waiting for. So two with Mr. Dagger Margosian and one with Mr. Glazier. I am going to step off the bench for like 2 minutes. I will be right back. All right, Mr. Glazier?
All right, thank you.
You're welcome. What are you doing, John?
Oh, good. I can't see you just.
Oh, that's okay. Attorney, I'm like, I'm sorry, you're just not on my docket. Well, we did a sit-in order for a motion on January 29th, and I'm like, finally, I'm like,
Sheets. Hold on.
Thank you.
28.
Please rise. Court is now in session.
Becky, she's
What's
so
that?
sweet. She told Becky, I said, she, while they're talking, she said, she went for you. I said, no, I'm good. She goes, no, I'm good. I'm good. Thank you.
All right. So I got Miss Underwood back. Let me see here, Miss Underwood, I'm gonna bring your client back. And then Things all here. Okay, Miss Underwood, I have Miss Quinones back. So I'm gonna pause you for 1 second so I can take care of something else. All right, so we are on the record in the matter of the people of the state of Michigan versus Darius Dwayne Collins Jr. File number 24-22082FH. So we have two things here today. We have a pretrial conference and we also have a show cause. So the show cause that was scheduled for January 6th of okay. So the show cause alleges that Mr. Collins has failed to test 2 times a week as required. He was placed on colors on December 20th of 24 and as of today, he has yet to submit to a test as required under those bond conditions, and that he admitted to using cocaine on December 17th of 24 to Mr. Coast.
Judge, we actually just did a urine screen 2 minutes ago. He was positive for THC, meth, and cocaine.
All right, so he did submit to that. We've also done a swab and that will be sent in. And then he admitted to cocaine use previously with Mr. Coase, and he admitted to cocaine and methamphetamine. What did he test positive for?
He tested positive for methamphetamine, meth,
okay,
cocaine, and also THC.
So he acknowledged using those substances today. So we have that, and then we are set for pretrial today. So my concern is he's under the influence of something at this point for purposes of this pretrial conference. I am so Mr. Glazier, I don't know that I can proceed today because I don't know what his levels are, his uses. So I, at this point, am going to remand him to custody of the sheriff's department, and I will set this for pretrial next week. Mr. Glazier, are you here next week?
Sure I am. What date?
Next week will be January 15. And I'll enter a plea of not guilty because I don't know, as I said, his ability to proceed today. So I enter a plea of not guilty on the show cause. We'll continue the pretrial to January 15 at 8:30 in the morning. And we'll do the notice of hearing, Mr. Glazier.
Thank you.
All right. Remanded the custody. Yes, yes.
I'm sorry, did you state a bond on that?
25,000 cash.
Okay, thank you.
All right, she'll come back. Your Honor, just for the record, I'm going to indicate that Mr. Collins has given me a Visa card, a Visa debit card, and a phone. Is that right? He wants me to give those to his mother. I don't see her here, but I'll take it.
Okay. Okay, we will make sure. Okay, thank you for placing that on the record, Mr. All right, Glazier. All right, so now, Miss Quinones. So, Miss Underwood, have you had ample time to speak with your client? Miss Underwood, you've had time to speak with Miss Quinones?
Yes, Your Honor, I have.
Miss, is she eligible for court-appointed counsel?
She is.
All right, Miss Quinones, you were appointing Miss Underwood as your attorney. Have you had ample time to speak with her?
Yes.
All right, Miss Underwood, how would you like to proceed today?
Your Honor, I would like the court to enter a not guilty plea on Ms. Quinones' behalf. Your Honor, I believe this is a matter that is currently scheduled for March in district court. I would ask, Your Honor, Ms. Quinones turned herself in.
Yes.
She reports to Ms. Walsh. I don't see that she's going to be a difficult person to get back here in court. I would ask for a PR bond in this matter, Your Honor, pending what goes on in district court.
Okay, Ms. Teskey, is Ms. Walsh available to weigh in today?
Your Honor, she's in the other court. I did get an email from Miss Walsh about Miss Quinones. So I'm not really sure what the issue is, but I am prepared to address.
All right, so she has charges for pending misdemeanors in district court that she failed to report. I don't know her history on probation. I don't know if she was doing well on probation before that. You know, I don't have enough information to make a bond. So if you can review that, I would appreciate it. Maybe you can review notes from Ms. Walsh.
Yes, Your Honor. Ms. Walsh currently has a pending show cause for absconding from September. She absconded from September until 12/6. Then she got arrested. She got a PR bond. She is currently living at the homeless shelter. Then she was then again arrested on 12/27 for disorderly. And one of the things says assault and battery, so I am pretty sure it's the same charge. But she was, the conditions surrounding that charge, the disorderly / assault and battery, indicate that she was with another known felon. They were dispatched to the residence, got into an argument. There were punches thrown, so there was a physical assault. And that is why this violation comes about.
So Miss Underwood, in light of the absconding that occurred at this time, I am not going to release her on a PR bond. Let me see what I did here. At this point, her bond is, I will set bond on each of these files at $2,500 cash surety, but I'm not going to release her.
Then,
all right. So I will set this for, I can set this for a pretrial out a couple weeks.
On what date, Your Honor?
A couple weeks, or how long would you like me to set this out?
I'm sorry.
How far out do you want a pretrial?
Not far, Your Honor.
All right, so what I'm going to do, Ms. Quinones, is set this out for a pretrial on January 29th. And and we'll see you back on January 29th at 8:30. All right, Ms. Quinones?
Okay, thank you.
All right, thank you. And I'll enter a plea of not guilty again. Thank you, Ms. Underwood.
Thank you.
All right, so I'm going to broadcast a message to my breakout rooms. Mr. Dagger-Margosian, I do have Mr. Castro here. So whenever you're ready, you can come back into the main meeting. So
I just realized there's that button there too.
I think I'm done with every jail window except for him. Mr. Dagger-Margosian, do you want me to bring your client back, or do you want me to leave him there and you take care of Mr. Castro?
We can bring Mr. Edwards back and we can handle that case. Thank you.
I mean, Mr. Olivares. Pop him back in. There we go. All right, we are on the record in the matter of the people of the state of Michigan versus Alphonse Eugene Edwards, file number 24-21995FH. I have Isaac Sneed on behalf of the people, and I have Michael Dagger-Markosian on behalf of Mr. Edwards. This is the date and time set for a pretrial. So, Mr. Dagger-Markosian, how do you wish to proceed today?
Well, Your Honor, today is it's the final settlement conference.
Oh, it is final pretrial. Yep.
And we are set for trial on the 16th. Our position is that we are ready to proceed.
So just to make sure my notes are rounded out, has there been a plea offer made in this file, Mr. Sneed?
Yes, there has, Your Honor.
Can I know what it is?
Yes, I'll just bring up my notes here. I believe the last offer from August was count 1 or count 2 with a sentence agreement to a 34-month minimum in MDOC.
Okay.
I think it's just a slightly different. It was an attempted count 1, dismiss count 2 sentence agreement for 36 to 60. I don't know if that's reflected in Mr. Sneed's notes.
Yeah, I have that on a different date. So yeah, I see that updated one. Thank you.
There were a few different versions of it, so I think that's
So an attempted count 1, so a 5-year felony?
correct.
All right, so he's charged with count 1, assault with intent or to do great bodily harm, which is a 10-year felony. If he got convicted at trial, it would be a 20-year felony because he's a third offense notice, right? And then count 2 is assault with intent to maim, which is a 10-year felony. If he got convicted at trial, it would become a 20-year felony. These would actually not stack because it wasn't committed in a place of confinement. And then, so the plea offer is to plead to an attempted count 1, which is a 5-year felony with a minimum of 36 months.
In fact, Judge. Yeah.
In what, Mr. Sneed? I'm sorry, in what?
Yes, that's correct.
And he's got credit from October of 24. Does that sound right, Mr. Dagger-Markosian?
That sounds right.
I don't know if there's credit since he was on a parole hold.
What, Ms. Teskey?
Two things. Since he's on parole, he will not get credit for the time he has served. And DOC can't recommend any more than 2/3 of the max due to Tanner law. So that would be 2/3 of 60 months would only be 30 months.
No, 40.
What, Mr.
Okay.
Dagger-Markosian?
I was wrong. Okay.
All right. So, Mr. Edwards, I didn't realize you were on parole, so you wouldn't get any credit for time served. So do you understand the plea offer, Mr. Edwards?
Yes.
Okay. So the plea offer would be plea to an attempted, and you would do 36 to 60 months. Do you understand that?
Yeah. Yes.
Okay. And more than likely, because you're on parole, I'm not quite sure what you're on parole for. What are you on parole for? You're on parole for assault with intent to murder. So I don't know what they would do. Usually they give you credit towards your parole violation, but I can never guarantee that because I'm not in charge of MDOC. But so do you fully understand the ramifications of taking a plea and going to trial, Mr. Edwards?
Yes.
Okay, and you wish to continue to trial?
He didn't offer me a plea. He took the plea back.
No, I just told you what the plea was. Did you hear the plea?
Yes, but he took it back.
No? Is it available today, Mr. Steen?
Yes, it is.
All right, so it's available today, Mr. Edwards. So if you'd like to, you could plead to an attempted assault with intent, which is a 5-year felony. And the sentencing agreement would be that you would serve 36 to 60 months with the MDOC.
I thought that offer was off the table until today.
They might have, but it's back on for today. Mr. Sneed was kind enough to say it's back on for today.
And if I can just add something, Judge, I would.
So hold on, I'm gonna pause it for a minute. Let's take care of Mr. Oliveras, and then you can go back in a breakout room with Mr. Edwards. How's that?
That's fine. That's fine.
Okay, so Mr. Edwards, we're gonna pause for just a moment. And then I'm gonna, because it's changed now, so I'm gonna come back to your case and I'm gonna take care of somebody else right now. That way you have more time to talk to your attorney about that change, okay? So in the matter of the people of the state of Michigan versus Castro Cash Oliveras, file number 24-21891FH and 24-21892 FC, and Michael, or I have Isaac Sneed appearing on behalf of the people, and Michael Dagger Margosian appearing on behalf of Mr. Oliveras. So, Mr. Dagger Margosian, do you need a breakout room with Mr. Oliveras? Yep.
Please.
Okay, so I'm going to put Mr. Oliveras and Mr. Dagger Margosian into a breakout room. You're the only cases I have left, Mr. Dagger Margosian, so I have all the time in the world right now.
Thank you, Judge.
So, all right, so I'm gonna open that breakout room. And then Mr. Edwards, I'm gonna put you in the waiting room and I'll bring you back in a couple minutes, okay?
All right.
All right, thank you, Mr. Edwards. All right. All right, now we're gonna take a little recess. So Mr. Dagger Margosian can do that. Ms. Page, you know what you gotta do. So,
Thank you.
she's like, thanks. We already did.
What to say?
Yes. Yeah. Yeah, make sure. Not.
All right, we are back with Mr. Oliveras. So, Mr. Degamargosian, whenever you're ready. Okay, how would you like to proceed on behalf of Mr. Oliveras today?
Your Honor, I guess I'd be asking for an adjournment so that Mr. McCready and I can sit down with you for a COBS. We did previously have a COBS on this, but there've been a little new development, so I think it would be prudent to set up a COBS with you.
All right, yeah, I have pleading and then no objection to guideline sentencing or something, but okay. So you can schedule that meeting through Miss Adams, but I'll set this over to do you want January 29 or February 5?
January 29 would be fine.
Okay, so Mr. Oliveras, I'm going to set this over to January 29 at 8:30 in the morning. Mr. Degamargosian, you can do the step in order to adjourn. And Mr. Sneed, can you sign your name with permission? I'm froze. If everybody, Mr. Sneed, I think I froze. So can you sign your name with permission?
Yes, please.
All right, so Mr. Degamargosian, thank you. And Mr. Oliveras, if they get in meet with me and we work something out, we'll bring you back in quicker, okay?
All right, thank you.
All right, thank you, Mr. Oliveras. You are all set.
All right.
Thank you. All right, so let's bring Mr. Edwards back and we can pop you in a breakout room with him. All right, Mr. Edwards, thank you. So, Mr. Degamargosian, Mr. Sneed was kind enough to extend that plea offer for today. So I'm going to open up a breakout room and assign you and Mr. Edwards to that breakout room, and you're all set. Get off the bench.
what did Mr. Collins give John? It was a Visa card, his app,
Not just a Visa card, a cell phone.
a cell phone.
He took the hat with him.
Oh, he did end up
Yes.
taking it? Okay. Thank you. Oh, it's just too bad. I didn't hear all rise.
Please do not.
Edwards is our last one, right?
Pardon me?
Edwards is the one we're waiting on. They're
Yeah,
still
the other
talking.
ones canceled.
Yeah, the one's like good
Sinclair?
friend. Sinclair, yeah, that got canceled.
And Belleria?
Yep. Yep,
Andrews is the last one.
yeah.
Okay, so let me get, you want me to bring your client back, Mr. Dagger goes in?
Yeah, please, John, thank you.
Okay. So we are back on the record with Mr. Edwards, and Mr. Edwards, thank you for your patience this morning. So Mr. Daggermark goes in, have you had enough time to speak with your client?
I have, Your Honor, and I know that this took a little longer than normal. I appreciate it. It's obviously a big decision, so I appreciate that.
How would you like to proceed?
Your Honor, after hearing what Mr. Sneed had to say regarding the plea deal, and after speaking with Mr. Edwards based on that, we will be entering a plea. I do want to just put put the outline of everything on record, just so everybody's on the same page and make sure everybody agrees with it.
All right, so go ahead.
So really this is kind of directed to Mr. Sneed, just to make sure everything that we're on the same page. It would be a plea to attempted count 1, dismiss.
So it'd be
count-
an added count 3, attempted assault with intent to do great bodily harm, right, Mr. Sneed?
Correct.
So attempted GBH, dismiss counts 1 and 2, dismiss habituals. There was, I did have a discussion with Mr. Sneed as far as any other potential charges regarding this investigation. I would ask that there would be an agreement for no, further charges to be added. I think would be fairly standard. And then for a sentencing agreement of 36 months to the stat max of 5 years.
Mr. Sneed, is that a correct recitation of the plea?
Yes, it is. We would also dismiss the habitual offender supplement.
Excellent. Okay, so thank you, counsel. All right, so
And
Mr.
Your
Edward.
Honor, I apologize. I would be asking for, based on my client's position of this case, I'd be asking for no contest rather than a guilty plea.
For civil liability.
Yes.
Mr. Sneed, do you have any objection? I'll make Mr. Dagger Margosian place a factual basis on the record.
No, I have no objection. Thank you, Your Honor.
So, Mr. Edwards, you want to raise your right hand? Can I see it on the screen? There you go. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so Mr. Edwards, you've heard the statement of your attorney and concurrence from the prosecuting attorney. They're going to amend the felony information to add a count 3, attempted assault with intent to do great bodily harm less than murder, which carries a maximum penalty of up to 5 years in prison. The plea offer is to plead to that added count 3, count 1, 2, any other potential charges stemming from this offense, as well as your habitual offender status would be dismissed at the time of sentencing. And the sentencing agreement is that you would be sentenced to 36 to 60 months with the Michigan Department of Corrections. Do you understand that part of the plea?
Yes.
And you also, and I know you already acknowledged this, but you understand because you're on parole, any credit you have would go to your flop on that or your violation on that.
Yeah.
Okay, Ms. Teskey, are you with us?
I am, Your Honor.
Okay. All right, so is it your intention today to plead no contest to that?
Yes.
Okay, are you satisfied with Mr. Dagger Margosian and the advice that he has given you?
Yeah.
And they've summed the agreement up in whole, and since it would be an MDO sentence, there's not much else they could add, but neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is. Thank you.
Mr. Dagger Margosian?
Correct, Your Honor.
And Mr. Collins, would you agree, or I'm sorry, Mr. Edwards, would you agree with that?
Yes.
Okay, so if a no contest plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. So, Mr. Edwards, do you understand that if I accept your plea, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Edwards?
Yes.
And do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right. Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Edwards?
No.
All right, Mr. Edwards, your attorney has advised you will be entering a no contest plea. So in my next question, your response would either be no contest or not guilty, okay?
All right.
All right, so Mr. Edwards, how do you wish to plead to the charge that on or about July 14 of 2024 in Adrian Township in the county of Lenawee that you did commit the offense listed under count 3, attempted assault with intent to do great bodily harm less than murder?
No contest.
All right, other than what was placed on the record in terms of promises, has anyone made any other threats or promises to you to induce you to plead no contest to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sneed?
No, I'm not, Your Honor.
Mr. Dagger Margosian?
No, Your Honor.
And there is a very clear sentencing agreement. So, and Mr. Edwards, it is your own choice to plead no contest, correct?
Yes.
All right, so Mr. Dagger Margosian, could you please place the factual basis for the plea on the record?
Your Honor, I would admit that at trial, the people would put forth evidence that on July 14th of 2024 in the Adrian Township, County, Lenawee, State of Michigan, that on that date, Mr. Edwards and Miss Butts were in the same household. There was a physical altercation in which Mr. Edwards attempted to assault Miss Butts, and that there was an injury to her, to wit her ribs. The injury would qualify as great bodily harm less than murder, and the form of the assault would come in the by way of a kick to her.
All right. Any additions or anything, Mr. Sneed?
Yeah, I just did notice with the date on the felony information, Your Honor, we did submit an amended felony information that included the additional count 3 back in October. But both the original information and the amended included the date of July 14th. I reviewed the police report, and I believe the correct date was July 4th when the incident occurred. So if we could just stipulate to that date, I think everything would be correct, and we'll submit the updated amended information today.
So Mr. Sneed, I have an information from October 14 that's not amended for purposes of the plea, but so it was July 4?
Correct.
July 4, Mr. Dagger Margosian? Would you agree? Okay.
Yes.
Okay, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on July 4 of 2024 in Adrian Township in the county of Lenawee that the defendant did commit the offense of attempted assault with intent to do great bodily harm less than murder by strangulation by kicking Cheryl Butts in the ribs area, causing injury, and therefore the court accepts the no contest plea. Anything else on that, Mr. Sneed, or has the court complied with MCR 6.302 B, C, and D?
People are satisfied, Your Honor. Thank you.
All right, Mr. Dagger-Margosian,
Nothing further, Your Honor. Thank you.
are you satisfied that the court's complied with MCR 6.302 B, C, and D?
Yes, I am.
All right, I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court will honor the Killebrew agreement and the plea that was placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. Who are you on parole with, Mr. Edwards?
David Face.
David Face, okay. So someone's gonna come over, they're gonna do an update and a pre-sentence report regarding this offense. Because you pled no contest for the purposes of civil liability, you don't need to make a statement about the events that occurred. Do you understand that, Mr. Edwards?
Yes.
But be truthful about your background, and they'll do a pre-sentence report. We will provide that to Mr. Dagger-Margosian. He'll meet with you in advance of sentencing, and we will see you back on February 21. Are you available that day, Mr. Dagger-Margosian?
I am. I'm wondering if there's just any possible way to get it sooner, just because this is dead time.
It depends on the schedule. We have to set out 6 weeks for MDOC. So I think that's about 6 weeks out, maybe even a little less. So we'll leave it on February 21 at 8:15. If by chance it comes in quicker and you want to move it up, you can, but I know potentially there might be a victim that wishes to speak, so we'd have to be able to accommodate that.
Understood. Thank you, Honor.
Okay, all right, so Mr. Edwards, we will see you back on that day. And do you want to come in person or do you want to appear via Zoom?
Person.
Okay, so I'll mark down in person. All right, you're all set, Mr. Edwards. Thank you. All right, Mr. Dagger-Margosian, I believe that concludes our criminal docket for the day.
Thank you. Have a good day.
All right, thank you, Mr. Sade.
Thank you, Your Honor. Appreciate it. Thanks,
You're
Mike.
done with me, Judge?
Done with you. Be
Great.
gone with you.